Welcome back to my channel. If you are new here, welcome. My name is Sharon, and on this channel, I would like to share with you summarized study notes on the various SQE topics that I am studying. These notes, as I post them on here, help me reset the information I'm learning so I can retain it. I'm hoping that these study notes can be of beneficial use to you on your study path on the SQE. Please remember, this platform is only for sharing of knowledge, gained through study and a place to interact with other students. You must read further and deeper on each SEQ module. On this channel, we gather and support each other to study and learn. If you have any constructive comments and/or information that you would like to share with other fellow students like myself on here, please place that information in the comments section below. Don't forget to like and subscribe to my channel, as I will continuously post on the various SQE modules. As I am studying through them, I look forward to engaging with you. Today's SQE topic is dispute resolution. Have you ever wondered how a legal dispute unfolds in court? Perhaps you've pondered the steps involved in resolving a dispute through the legal process. Well, today we're going to delve into this very topic. Disputes arise when there is a breach or perceived breach of one party's legal rights by another party. Let's look at some differences between dispute resolution and litigation. Alternative dispute resolution, also known as ADR, involves arbitration and mediation. In arbitration, a third-person PR party is appointed to decide a dispute between parties. In mediation, a third party is appointed to help parties reach a resolution themselves. These two aspects of arbitration and mediation sit outside of the court system. With litigation, on the other hand, is when one party uses the court system to commence a legal claim against the other party. With the route of litigation, the court will decide the outcome of the claim if the two parties cannot agree. The first step in the dispute resolution process is the pre-action protocol. This initial stage involves parties engaging in discussions about the claim and considering alternative dispute resolution, or ADR for short. Next up is issuing the claim in the appropriate court. Here, the claimant must decide which court is the most suitable to file their claim. For claims of higher value, the High Court is typically the go-to, whereas lower value claims are usually heard in the County Court. Following this, we have the statements of case. These consist of the legal documentation involved in a claim. They include the claim form, particulars of claim, defence, reply to the defence, request for information, and a counterclaim. A handy acronym to remember these is CPDRRC. Then comes the service of claim. This must be served on the defendant within 4 months from the date the claim was issued by the court. The claim form is deemed served on the second business day after it was posted or personally served, according to the Civil Procedure Rules. Part 20. Claims and defences allow the defendant to issue a counterclaim against the claimant for any losses they incurred, provided these losses arose from the same facts as the claimant's claim. Next, the court allocates the claim to the appropriate track and issues directions. These tracks can be the small claims track, fast track, or multi-track, with the County Court hearing small and fast track cases and the High Court or County Court hearing multi-track cases. As the case progresses, it may be brought before the court for a case management conference, or CMC. This conference considers any directions that may be needed. If costs are being examined, this hearing is referred to as a Cost and Case Management Conference, or CCMC. Throughout the claim cycle, parties can still consider alternative dispute resolution at any point. This is known as without prejudice negotiations, where parties can make offers to settle without prejudicing their position. Interim applications. While a claim is pending in the court, a judicial decision application may be made. Part 36. Offers. I used to hear about Part 36 offers in legal conversations, and I was never quite sure what that encompassed. Now, through my learning and study, it's become much clearer what it is. The civil procedure rules that we discussed at the beginning of this module provide a pathway for offers to be made to settle a claim. Part 36. Offers have a significant cost implication if the offer were rejected but not beaten at trial. Part 36. Offers are used very much in litigation. It is important to bear in mind that both the claimant and the defendant can make a Part 36 offer at any stage of the proceedings, including pre-action. Again, I would urge you to read further around Part 36 offers. Trial and judgment. Where the parties are unable to resolve their dispute, the case will go to trial. If the claimant is successful in their claim, they will be awarded damages, which is a financial sum to compensate them for their loss or injury sustained. The court will award a judgment which obligates the defendant to pay. There are other factors that come into play during the trial stage of dispute resolution. And I would like you to go and read on the following: witness evidence at trial, hearsay, and expert witness, award of cost and interest. Upon judgment of the claim, the successful party is entitled to recover their costs, and these may be on a standard or indemnity basis. A standard basis is the court will decide if the cost was reasonable in favour of the paying party. Indemnity. The court may decide to make an indemnity cost order against parties to penalise them for unacceptable conduct. Enforcement. This is the final step of dispute resolution. This can occur if the defendant fails to pay the judgment or the cost awarded to the claimant. The claimant can proceed to use various methods to enforce judgment. These can be attachment of earnings order or sale of goods belonging to the defendant. Appeals. With most court cases, there is room for appeal, and same applies in dispute resolution. The losing party can appeal, and this appeal can be heard by a higher judge in the same court, or the appeal can progress to a higher court. Do note, though, that there is no automatic right of appeal in civil cases. Permission to appeal by the party concerned will need to be sought in the court that heard the case at trial or to an appeal court. You can go and read a little more around grounds for appeal, time limits of appeal, and what happens at the appeal hearing. So, in summary, the dispute resolution process consists of several key steps, which are as follows: pre-action protocol, issuing the claim in appropriate court, drafting and serving each party with statements of case, court allocation of claim to appropriate track and issue directions, case management conference, without prejudice negotiations, interim applications, Part 36, offers to settle, claim, trial and judgment, award of costs and interest, and lastly, enforcement. Permission to appeal can be sought by the defendant, but remember that there is no automatic right to appeal civil cases. By understanding these steps, we gain insight into the mechanics of the legal process and how disputes are resolved in court. Well, my fellow students, that wraps it up for this study session. I hope you have found it helpful as a foundation to build on further reading, as I always encourage you to do. I will be posting other notes from my study on dispute resolution in the coming posts, so be sure to look out for those. If you would like to receive and be notified of future SQE content, be sure to hit the like button and subscribe. Let's carry on building a supportive learning and study network that will help other students. Feel free to share constructive comments and ideas that will assist the study process and any questions that you may have, as well as how you are progressing with your SQE study. Till next time, when I will be back with more notes on dispute resolution. Remember, you don't understand anything until you learn it more than one way.